momentarily. If you would please record. Thank you. We want to welcome you to today's program titled Return to Business in the Midwest, What In-House Counsel and HR are Grappling with During COVID-19. At this time, all participants are in a listen-only mode. We encourage you to submit questions for any of our panelists throughout the discussion by typing them into the Q&A box on the right-hand side of your screen. If for any reason we do not make it to your question, we will follow up with you individually in the coming days. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down as it will not be reread and is required for CLE credit. This session is being recorded. Copies of the webinar recording and materials along with the CLE attendance form will be distributed to attendees in the days following the webinar. This presentation has been prepared by Seyfarth Shaw LLP for informational purposes only. The materials discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our moderator, Corey Hirsch, Chicago Office Managing Partner. Corey?
Thank you, Kristen, and thank you to the audience for joining us today. Today's program will be packed with helpful information on leave and accommodation issues and how best to manage workplace safety during a global pandemic. After we hear from our colleagues on the legal landscape, my Seyfarth colleagues on the legal landscape, we will then get the perspective of two well-respected in-house leaders who have been navigating these issues throughout the pandemic and are continuing to grapple with the decisions and COVID-19 worries. Let me start by introducing you to the panelists. First, you'll hear from Ellen McLaughlin regarding leave and accommodation issues to consider during COVID-19. Ellen is a partner in our labor and employment practice. She's a resident in our Chicago office. Her practice covers a broad range of employment issues, and she is frequently retained by companies as their trusted advisor, not only on day-to-day issues, but also high-profile bet the company matters. She regularly consults with employers to implement nationwide practices and systems which are both legally compliant and meet the employer's business needs. Ellen is also the national chair of our firm's Seyfarth Women's Network. Next, you'll hear from Dan Birnbaum on how best to manage workplace safety issues through COVID-19. Dan is an associate in our labor and employment group and is also located in our Chicago office. He focuses on all facets of workplace safety, including assisting clients when accidents occur. He also has significant experience in traditional labor law. Clients rely on Dan's understanding of how workplace safety issues can heavily impact labor relations. Finally, we couldn't be more pleased with our in-house perspective, and you don't get much better than our two guests here. First, we have Joshua Marcus. Josh is the General Counsel of North America for Ardagh Group, a global packaging company providing some of the most recognized consumer beverage and food products around the world. In his role as General Counsel, Josh covers a broad range of legal issues, including mergers and acquisitions, regulatory and compliance, trade, and government affairs. Ardagh North America operates 28 locations in 13 different states and includes a mix of office settings, manufacturing facilities, and an innovation center. Finally, we welcome Scott Gross. Scott is the Vice President and Chief Employment and Labor Counsel for Treehouse Foods. Treehouse is a leading manufacturer and distributor of private label packaged foods and beverages for retail, grocery, food services, and industrial customers. At Treehouse, Scott is responsible for all employee-related issues, including drafting and revising employee policies, OSHA regulatory and compliance matters, and counseling and advice on HR day-to-day matters. Treehouse operates approximately 40 production facilities across the United States, Canada, and Italy. Panelists, I look forward to the conversation. Ellen, would you like to kick us off?
Corey, I just want to make sure everybody can hear me.
Ellen, I hear you perfectly. Thank you.
Perfect. I yearn for the days when we were all together and you just got up at the podium and started speaking and didn't have to mute and unmute yourself. So it's great to be with everybody today. I'm going to spend the next 10 minutes talking about where we are with respect to leave of absences and accommodations during COVID-19. Some of what you'll hear will be things that you have dealt with now for the last few months, which to me seems like a lifetime, and I'm sure it does for you as well, and then what's on the horizon. Next slide, please. And next slide. So let's talk about some reasons for leave. And what I always tell clients to start with pre-COVID, right, was, well, check to see if the individual who has a medical condition or is caring for a family member, if they might be eligible for FMLA. I will sound like a broken record today in my 10 minutes to say we should not be throwing out what we're all used to in analyzing a request for leave or a request for an accommodation in terms of what we've always done under the FMLA or under the ADA. So with respect to COVID-type leave questions under FMLA, it would trigger possibly leave for the employee's serious health condition or leave to care for a family member with a serious health condition. Next slide, please. So let's talk about when FMLA leave might be available to an employee who is otherwise eligible. So if somebody is symptomatic, it really is only FMLA leave if it rises to the level of a serious health condition. And you go back, right, to the definition of serious health condition, and it could be triggered, the need for leave, if somebody is receiving inpatient care or has an absence of more than 3 consecutive calendar days and has received treatment twice by a healthcare practitioner or once by a healthcare practitioner and then is under a regimen of continuing treatment. So you may have somebody that actually is symptomatic and might not meet that definition, which means we fall back on looking at the medical certification form to see what that healthcare provider has said about that individual's, having COVID and being symptomatic. What about if somebody's tested positive? Well, again, we get back to, well, they could test positive but be asymptomatic, doesn't rise to the level of a serious health condition. If they've been exposed but are asymptomatic, same analysis, doesn't rise to the level of serious health condition. The one that employers that I work with are struggling with the most is, well, what about somebody who is a high-risk individual? They have a condition that is noted by the CDC as high risk, or perhaps their healthcare provider has said they have a condition they feel is high risk, and they say, I can't come back to work, or I can't work in this environment. Well, that's the toughest one, I think, for employers. Just because they have a condition that may be high risk doesn't necessarily mean they are eligible for FMLA leave, but really what you have to do is look carefully at the medical certification form to see what their healthcare provider is saying. I mean, I've seen things that say, well, they have a fear, right, of coming back to the workplace. Even if they have a fear, having a high-risk condition plus fear, that's what's stated on the med cert, isn't enough. If the doctor says, well, it might be better for them, might not be enough. If the doctor is clear that if they would return to work with whatever high-risk condition they have, and they would be a direct threat to their own safety given their condition, well, that's a different story. So the point here is you've got to carefully look at what the med cert form actually says. Mandatory quarantine, we're seeing a lot of that now with the travel orders. Doesn't mean somebody has a serious health condition, so that would be not eligible for FMLA leave. Next slide, please. So I do want to point out for those of you who are subject to the Families First Act, which would be your under 500 employees, that there has been a recent decision, August 3, out of the Southern District of New York that has vacated certain aspects of the DOL's regulations on that law. I'm not going to spend any time on that today. We've put out a management alert. If you have questions about it, you should contact your Seyfarth lawyer. But there are the 4 regs that were vacated, and the one I think that struck people the most, frankly, was the work availability requirement, where this court said that work doesn't have to be available for people to partake of leave in certain circumstances. The big question of the day is, well, what now? And we don't know what now. Certainly, if you have facilities in the Southern District of New York, you need to pay attention to this decision and follow, follow the exclusions now, but even that isn't clear. So we're in this kind of limbo land of whether or not you should be following this decision. And again, that's a risk assessment. We're waiting for DOL to do something. Are they going to, are they going to appeal? Are they going to revise their regulations? We simply don't know. But we do have this decision out there. And if you are subject to the FFCRA, you should certainly be following that. Next slide, please. And now I just want to quickly go over state leave law updates. So this is the thing that I think any in-house or outside counsel practitioner in this space tears their hair out about all these state leaves generally. And now we have state leave laws, which you need to be aware of if you have a location in a particular state. The states continue to have additional paid sick and safe time laws, paid time off laws, paid family and medical leave laws, new things that you need to, once you go through the federal assessment on, is it FMLA leave, is it ADA leave, then the question is, and what about our state laws? Next slide, please. You can just look here at, we've grouped it by group 1, group 2, group 3 in terms of entirely new laws, amendments to existing laws, non-binding guidance. Next slide, please. This is just a handy-dandy way of looking at it in terms of where do we have entirely new laws. And probably not surprising, California has a ton of them. And in California, it's also extremely difficult because it can be by city or by county. Here in the Midwest, Michigan has a new law. And I don't really think of Colorado as Midwest, but we're getting closer, and they have a new law. Next slide, please. Amendments to existing laws. You can see the chart here. Next slide, please. And no paid sick leave or PTO laws with non-binding guidance. I mean, lots and lots of them, including Chicago and Cook County. Next slide, please. Midwest Roundup, and again, this is just for your reading pleasure because the deck will be sent out of the laws that we have now in Chicago, Cook County, Michigan, and up in the Minneapolis, Minnesota area. Next slide, please. So let's now talk about leave under the ADA for COVID-19 reasons. And here I am, sounding like a broken record. We always need to get back to how we would have assessed a request for leave when someone isn't eligible for FMLA or has exhausted as to what we would have done pre-pandemic, still engaging in the interactive process, always asking for medical documentation. And what I have seen sometimes is that we are not pushing as much to really understand why that individual needs leave based on a medical condition. We should not, just like we should not have before, accepted any medical documentation that is vague. We certainly can ask that healthcare provider for more information. What I have found that has worked kind of well is if we're having this dialogue with the healthcare provider to consider providing them with your safety protocols so that they have a sense as to what you're actually doing in the office or in a production facility in terms of keeping somebody safe. And that may actually change their recommendation as to whether or not that person can return to work or needs to remain on leave. Likewise, to tell them what exactly that individual is doing at work so that they understand, are they going to be in an office and not seeing anybody? Or are they going to be very close to people such that they have to wear masks at all times? So consider that. Also, and again, kind of basic ADA, always explore alternative effective accommodations and understand that you can propose something to the employee other than what they're asking for. Next slide, please. So let's say somebody comes forward and says, I think I have a disability and I need leave. Well, again, we work through the analysis. An employee with COVID-19, possibly. It's not a foregone conclusion that they have an ADA disability. It depends on their symptoms, their diagnosis, as well as duration. Don't forget that conditions of short-term duration are not covered by the ADA. A high-risk employee, possibly. Kind of the same analysis under FMLA. Remember, age is not a disability. So simply because somebody is 70 doesn't mean they have a disability. Those high-risk conditions reference CDC and the WHO guidance. A fear of returning to work, if it's a generalized fear, not covered as a leave for an ADA leave, unless they have an underlying condition such as anxiety that might be exacerbated by returning to work. And caring for a high-risk family member, of course, isn't covered under the ADA. Next slide, please. Let's talk about other accommodation examples. This one I think maybe many of you have worked through. Pre-pandemic accommodation. If an employee with a disability needs the same reasonable accommodation at a telework site that they had at the workplace, you have to provide it now at the telework site, their home, absent some undue hardship, and you have to pay for it. Next question, or next slide, please. A post-pandemic accommodation question, and I think this is one that we're all going to be facing very soon. Well, the fact that an employee worked remotely during the pandemic necessarily mean it's not an undue hardship to have them work remotely post-pandemic. I think we're all concerned about that because many employers still want their employees in the workplace. So we just don't really know. The EEOC on March 27th said, well, this working at home during the pandemic could serve as a trial run that could obligate the employer to grant the accommodation request after the pandemic ends. The good news, though, is that they did say they recognize that work was provided at home during the pandemic for that sole reason. Two notes here, and things to kind of shore this up when somebody returns to work. I would guess most of you probably sent something out to your employees saying the reason we're allowing you to work from home is the pandemic, so it's not your normal course of business. If you have somebody who is working from home and is not able to perform all the essential job functions, then you need to be noting that and documenting that and certainly requiring that upon return to work. Next slide, please. Face coverings, probably everybody's favorite or least favorite. Can you require them at work? Yes, there's a legitimate business purpose, safety, and of course we have many state orders that require it. Communication to employees and training on how to wear them is key. What if you have somebody that says, well, I just don't like them? I think the better part of valor is to talk with them, explain why you feel they're necessary, refer to the state order if you have one. But simply saying I don't want to wear it isn't good enough. If they have a medical condition like asthma or anxiety where they feel claustrophobic, you work through the interactive process and I've listed here some alternatives that you might be able to provide them. I don't know if anybody has seen this face mask exempt card, but it's a fake. So somebody may say to you, well, listen, I have a face mask exempt card. Here you go. And so I don't have to wear this at work. This is a fake card that has been circulating, and like any other ADA situation, you would get medical documentation that somebody needs the accommodation of not wearing the face mask. And lastly, next slide, what's on the horizon? So this is going to be very interesting, I think. I have had a number of questions from employers about the vaccine and whether they are going to be able to require it when it's out as a condition of employment or continued employment. So the EEOC has said that they are going to issue guidance on this issue. We haven't seen it yet. What we rely on now is some prior case law that frankly isn't all that helpful because it's mainly in the healthcare setting. You would argue that the vaccine during a pandemic is job-related and consistent with business necessity, but of course, just like in the healthcare setting, you would have to accommodate somebody and work through it if they had a health condition, which typically would be immunocompromised, where it would be dangerous for them to get the vaccine, or had a religious objection. Some religions, as you know, do not believe in immunizations. So this is on the horizon to come, and here we are back a little bit where we started. You would always have to look at your state and local guidance. New York and California would be tougher to enforce a vaccine. Globally, it's pretty tough to enforce required vaccines, generally requires employee consent. So look for that on the horizon as sort of the next COVID issue. And with that, Corey, I'm going to turn it over to you or to Dan to go through various safety policies and protocols.
Thank you very much, Ellen. I appreciate it. This is Dan Birnbaum, focusing on workplace and safety issues, and it has been a very, very interesting time in my career, to say the least, based on what has been happening this year. For purposes of my presentation today, I want to focus on OSHA, the Occupational Safety and Health Administration's enforcement efforts. Just taking a step back from a legal standpoint, OSHA is able to promulgate standards regarding safety, but to do that is a somewhat time-consuming process. And the way OSHA has been enforcing the act, really, rather than implementing new standards or new legal requirements or anything like that, which honestly could not possibly keep up with this pandemic, OSHA has shifted its enforcement priorities. And that really is the focus of what I want to discuss today and purposes in terms of our purpose today for return to work issues. So the two things I want to cover in depth here are, first of all, the first would be employee complaints. And employee complaints, when I speak about that, thank you very much, is when employees anonymously file a safety and health complaint. And for purposes of talking about complaints, OSHA will ask for a written response, including documents and photos regarding this complaint, which an employer has to respond to within 7 days. So obviously the employers want to be mindful of their safety, health, and policies. And that starts with conducting a COVID-19 risk assessment. And what that will focus on is what type of facility you are operating. Now, if we're dealing with environments where we expect individuals to actively bring COVID-19 on site, say hospitals or healthcare, obviously the requirements for those sorts of agencies in terms of PPE or physical barriers or engineering or administrative controls will be the highest. Most employers will fall into the middle category of medium risk, especially the ones that are starting to open now, where workers can have contact with travelers or contact with the public in community spread areas. And for purposes of OSHA enforcement, we believe that's really where most of the enforcement effort is concentrated, as that's most of the workforce. And then the low risk areas, which is somewhat of the administrative companies and similar sorts of situations where the workers don't necessarily have contact with the public, work in spaces individually and don't have that exposure. In terms of facing citations, we would think, and they're just starting to occur now, that the hospitals and healthcare are the ones that are going to be at the highest risk of facing OSHA citations. Prior to this pandemic, the most similar situation was the Ebola virus, in which a Dallas hospital was cited because they did not effectively protect their employees, and a nurse contracted Ebola. Outside of that situation, we have not seen OSHA issue citations for these types of situations, but still we have to be mindful of our policies and procedures to limit the administrative headache that OSHA can cause. Next slide, please. So part of this involves preparing an infectious disease preparedness and response plan, which hopefully most of us have already done, and if not, should certainly do in anticipation of opening up again. While obviously we want to focus on COVID, it's very difficult to say where we're going to be 6 months from now, a year from now, and certainly given the new world we've woken up in, where we might be 3 or 4 years from now when other viruses may arise. So the plan would want to consider the risk associated with the work site, exposure, how viruses are spread, how we can limit that exposure, and an individual risk factor of workers, such as old age and chronic medical conditions. Next slide, please. So a part of this will obviously be implementing basic infection prevention measures, which most of us have already heard ad nauseum and are most certainly familiar with all of the issues on this list. Circling back to my original point on the OSHA complaints, is this is what we're seeing employees complain about very frequently. Employees will call OSHA anonymously, file a complaint and saying my company isn't properly wiping down every doorknob, or is not, ensuring that employees wipe down the microwave after use. And while this seems very specific or almost nitpicky in what's happening, the issue is that OSHA is under an obligation to respond to this. And hypothetically, if OSHA is unsatisfied with the employer's response, what can happen, and the situation we're trying to prevent here, is OSHA can now come on site and conduct an inspection. And what's problematic about COVID-19 is COVID-19 infects all places of the workplace where employees are located. So presumably OSHA could come on site and, rather than say inspect a forklift accident or an area where some other amputation occurred, or a specific location of your facility, now they can conduct what we call a wall-to-wall inspection, where they cover every inch of your facility where COVID-19 can spread. And if they see anything, even if it's not COVID-19 related, if they see an employee bypassing a guard, operating a piece of machinery incorrectly, now they can cite you for that. And going back to a point I mentioned earlier, while we don't anticipate that COVID-19 citations are likely, what this essentially does is it creates an environment now where OSHA can come on site under the guise of looking after COVID-19 issues, and even though they may not issue a citation, can now cite you for these other health and safety issues. So implementing these measures and preventing complaints and OSHA coming on site is a critical issue employers should be focused on as they do these return to work issues. Next slide, please. So in addition to individual cleaning, the second most common complaint we're seeing is robust housekeeping, and specifically what employers are doing to make sure that common areas are cleaned, as well as what employers are doing to disinfect areas when a confirmed case occurs on site, and how to clean that up. And again, very important advice that hopefully we're all aware of now, but need to keep reiterating and hammering home until it becomes a habit among our workforce, which is frequent cleaning of common spaces, restrooms, break rooms, lobby, and frequent cleaning of commonly touched areas. I was speaking with a client earlier this week facing a complaint who was expressing to me the difficulty in making sure that, say, we're always wiping down the doorknobs when we touch them, or we're always wiping down the kitchens when we, go in there. And the response to that would be, well, we can post signs that remind employees of this. We can do retraining to hammer it home. But if it becomes a difficulty or administrative headache, then we can also do what other employers are doing, which is simply to close the space down until it becomes feasible and possible for us as companies and as employees to make sure we're adhering to this. So no right or wrong way to answer these questions, but at the end of the day, it's always going to be a good faith, reasonable effort by the employer. So long as we're doing that, we're protecting ourselves from an OSHA standpoint. Next slide, please. Hand in hand with the sanitization is the social distancing aspect and ensuring that we're giving each other enough space to work without necessarily coming in contact with each other. So the 6 feet of social distancing, staggering shifts to make sure we're limiting the amount of employees on site at a time, controlling employee flow, maybe designating certain entrances or exits. And if you're in a building with shared space, such as elevators, working with other companies in the building to ensure that, you know, these concerns are addressed, say, in common areas where your employees may be exposed to other employees, as well as time clock issues, making sure that any sort of time clock should be sanitized if our employees have to touch them, and the common areas as discussed. Next slide, please. Also, developing a process for identifying and addressing sick employees. So isolating such employees, restricting the number of people they come into contact with, the contact tracing, cleaning, and disinfecting. And I will say that this can vary state to state. So certain states have what are called state plan states, which means they have a state OSHA that regulates specifically that state. And in the Midwest, that would include Minnesota, Iowa, Indiana, Michigan, and Kentucky. Or otherwise, I suppose Illinois, Wisconsin, and Ohio are the only ones that are controlled by federal OSHA. And the reason this is important is because each state is now issuing its own guidance. And I can say, for example, in North Carolina, they don't want employers doing any sort of contact tracing. And in their guidance, they say that employers should be enforcing mask usage, advising about hotlines, things of that nature. But in terms of contact tracing, they put that solely in the hands of the local health authorities. So the advice given today is obviously only effective as good as August 13th. It's important of us as human resources and companies to continually be assessing what the latest guidance is and making sure we're adhering to whatever the state plan state is telling us to do. Next slide, please. A list of engineering and administrative controls that can be implemented on site, which we're probably all familiar with: installing barriers, limiting third parties, restricting employee travel. You'll all have access to these slides, but things to consider. Some may not be appropriate now. Some may be more appropriate down the road as maybe more employees feel comfortable to come back to work. So again, it's an ongoing process, and although some of these may not necessarily be necessary at this point, we always want to be continually assessing our workplaces, our employees, our workforce, and understanding what controls need to be put in place in light of that. Next slide, please. Employee training, again, reiterating, obviously, the points that we've been covering today just to make sure they're habit for our workforce, which is why open communication and training is always good. Further, in terms of minimizing complaints to OSHA, we found that when companies are very open with their workforce and conveying to them as much information as they possibly and legally can, that the workforce will usually file less complaints and are more satisfied with what the company is doing. So open communication is always good. And obviously, as things change and update, we want to make sure our employees are aware of the absolute latest guidance. Next slide, please. Third parties, again, understanding who's coming on site and making sure the controls are in place to account for our customers, vendors, and visitors, and reassessing as more customers come on site and how it progresses, where our policies need to be. Next slide, please. Contingency planning, a point I also covered briefly, is that we're not exactly sure where we're going to be 6 months, a year from now, 3 years from now. So understanding, you know, trends we're seeing, and then making those sorts of plans going forward, whether it could be more employees being absent, how we can conduct essential operations with a reduced workforce, or any interruptions. And understanding, of course, that the safety aspects of where we are increase exponentially as we work on reduced employees. As more employees are working maybe longer or unconventional hours, that's what we see usually leads to accidents. So understanding that if we reduce our workforce or we shift hours or make changes to the workplace, how that impacts safety, and then planning for it. Next slide, please. And then just very briefly here, as we return to work, we want to make sure as we're returning, all of our equipment's up to date. You know, we're going around making sure our fire extinguishers are up to date and haven't expired, doing visual inspections, and, you know, slowly reacclimating the workforce into the workplace after being away from work, because again, this is when the accidents happen, when you've been inactive for several months and now you're coming back. So gradually moving into that and keeping safety in mind. Next slide, please. And then just very briefly, I want to touch upon this. In addition to the complaints, the other major safety issue we have been dealing with is employees who are concerned not to come to work because of safety, saying, I can't come back to work because I'm nervous that I'm going to catch COVID-19 and potentially die. And in that regard, there are certain provisions under the OSHA Act that will protect workers when certain elements are met, including that the employee is refusing to work in good faith, and a reasonable person would agree that there is a real danger of death or serious injury. And from a legal perspective, again, we are advising that if acting in good faith and reasonably, and employers are making their best efforts to protect their workforce, they will protect themselves from this sort of liability. And that includes adhering to OSHA guidance, CDC guidance, and continually reassessing and implementing what needs to be done to make sure that their safety measures are completely up to date. If that is done and an employee unfortunately does contract COVID-19 and becomes ill, from a legal standpoint under the OSHA Act, it's more likely than not that the employer won't face any sort of legal liability, but of course our workforce and safety is paramount, and we want to make sure we're protecting everyone to the extent that we can and doing whatever we can to address. So before I conclude, I just want to reemphasize that as employees return to work, our best advice is to be open and communicative with your employees, explain to them what the company is doing to alleviate employee concerns, solicit advice from your workforce to ask what can we do better, and show that to them so that employees feel safe in the workplace. The complaints are limited, the OSHA exposure is limited, and most importantly, we're keeping everybody safe. So thank you everybody very much, and I will turn it back over to Corey.
Dan, thanks. Ellen, thank you as well. Before we open it up into our Q&A session, I just want to provide the CLE code for everybody, and the CLE code is SS617. That's SS617. Well, now as promised, we wanted to have a Q&A with our esteemed colleagues, and quite frankly, we've worked with both Joshua and Scott for a period of time, both as clients and in preparing for today. We would like to start off first with a general overview of some of the challenges that they're seeing, and then become more narrow and specific in our questions, focusing on safety and leave and accommodation. So, Josh, I'm going to start with you. And one of the concerns that we hear over and over again is how do we keep employees engaged, connected, and motivated? I'd love to hear what the RDOC group has been doing and any suggestions you may have for others.
About that, because it's we've gone through this period since the pandemic created where we had all those initial issues. I'm fortunate. RDOT is a critical infrastructure business, so our plants have remained open during this period, and we supply products to, in fact, even Scott's company is a customer. So from my optic, it's the ability to keep our plants open. First and foremost has always been about keeping people safe, That's first. Second was keeping plants open. That took us through basically the end of April, May, some thereabouts. And while we've gone into this new stage of maybe a bit of a limbo period where we're talking about, how do we keep our offices now? And when that's in the engagement of how do we keep all those people who've been working from home for the most part engaged, understanding that they're still part of this organization, they could come back to the office or not, depending upon a variety of the variables, and to ensure that people aren't just lost and feel isolated. And so to that, I'd start with Daniel hit the point about communication. That is critical. You need to always communicate as being open as possible about where we are, whether it is a company or a team leader and manager of folks, of the issues that we're facing, the answers that we may have, and also being very transparent to the things we don't know yet. When will the office be up and running at full? We don't know the answer. If anyone says that answer, well, I think they're probably mistaken greatly. It's a fluid situation. We have to acknowledge that from the start. It's setting up things as simple as my teammates created through our comms and HR group, a brilliant idea. In fact, I've got one later today that if I could attend will be a Zoom cooking class. I mean, something is that simple of colleagues who are participating and joining together because there's the part that we're all missing out is that camaraderie that we would otherwise have in the office, the coffee chat, the whatever it would be, that moment. So anything you could do for that, I see a variety of examples of virtual and webinars and Zoom chats and all, and Teams meetings where you can have that. From my team, I know that I've strived to keep in touch with people probably more often than I would have pre-COVID, because I think I would have let some of these things just go until we had our more formal meetings, or if I've been traveling to one of the locations where I have part of my team and caught up there. But I think it's even been more on my mind day in and day out to not let probably 3 days at the most go by where I've not had at least a 15-minute chat, even if it's on nothing to do with work, with each of my teammates and the people that report to me.
Thanks, Josh. I appreciate it. Josh spoke a lot about getting through that initial couple of months. Scott, Treehouse has been an essential business and been, just as Ardagh has as well, and running from March on. In the progression stage, both companies are probably maybe well ahead of where some others are in terms of opening. But Scott, I'd be interested in sort of what's keeping you up now that's related to the pandemic. What are the concerns that you have?
So other than the obvious anxiety personally with the family and all, I think probably the two things that I think most about today are the next surge, which is apparently on its way by many of the experts. So what can we do now to help us the next go around? And like you said, because we've been wrestling with this since it began, and we've, like Josh, we've been running essential industry. We've been actually running even more than full steam because a lot of our food products have run off the shelves with people stockpiling. So we've kind of had to hit or miss, develop these policies, procedures, practices, and then adjust them as we go on. So we feel like we've come to a point where we've got things running okay now, or as best as we think we can, but we got to be ready for the next go around. And, the couple of things that come up with that is, one, we're stockpiling. We're thinking about stockpiling. Of course, inventory is an issue, so we think about that, but also the technology that's coming out and we are evaluating or have adopted, the temperature testing equipment. We're assessing COVID testing. We haven't done that yet, but we're looking at what people, when would we test actual employees for COVID itself? What situations and what communities and the like. And the companies we're talking about that testing who have really done some amazing things technologically we're thinking, focusing on possibly stockpiling testing as an option. The other thing we're doing is we're thinking about how do we keep the knowledge we've gained from dealing with this over the last several months and take it to the next level. We're kind of stepping back and assessing what have we done from day one, what have we learned, and how do we communicate that to all the folks at our plants, our 40-plus plants, the plant managers, HR, EH&S, continuous improvement, so that when these things pop up again, which they will, the one-off issues, the strange issues, they'll be ready to do that. The other thing that I think we're thinking about is something most businesses probably are thinking about is liability for a person who is an employee and tests positive and decides to go after the company for it. We've seen a lot of jurisdictions, and there's a lot of talk federally about limiting liability as long as employers are aggressive and do a good job of doing the best possible. But that's something that we worry about. And so we have implemented a lot of practices to help minimize the liability if, in fact, there aren't protections in place, and then we get those lawsuits and those allegations.
Thanks, Scott. Appreciate it. I want to switch slightly for the group and sort of look at safety. Josh, how are you managing safety complaints, concerns of employees on the manufacturing side of the organization?
I think the first thing is take the complaint seriously. Let's look at it, make sure, are we understanding the individual, if it's direct or was it a hotline call, a bit different process. Where is there something that's being missed in communication to specifically in that setting, the manufacturing, which we're really probably talking about the hourly employee cohort, and have we failed to communicate properly, to explain, to train? So I think it's first taking a look at that holistically from internally. And there could be the point where, no, we've done everything right and it's just simply that individual's confusion. And hopefully it's an open dialogue and reasonable people will understand. But I think it also goes to the points that Ellen and Daniel both touched upon. It's about transparency of the plans and what we've been doing to keep our people safe, and reiterating that message, which is really day one. I mean, it's the first thing every day, every meeting, and it's the thing that we can't take our attention away from.
Thanks, Josh. I want to build on that. Certainly the communication, but I think regardless of the communication, Scott, we tend to have folks who are afraid to return to work, whatever we put out, and they have no heightened risk or medical condition. How are you managing that population? We, as you rightly said, have dealt with that almost weekly. That comes up. And no matter how effective your communications, no matter how visible and effective your safety matters, employees, a number of them rightly or understandably are afraid and see risks. It comes down to often they see risks in the person they're working 6 feet away from who's not wearing their mask properly. They see risks in a rumor that comes out that so-and-so's family members all had positives for COVID. And so what we do is kind of a more sophisticated or more elevated set of things that we would do in any situation like this. And I say that because Ellen mentioned, sort of thinking about ADA, for example, as what you would do anyway. Well, we always try to go back to first principles because they often do this for us, which is talk to the person, understand the situation, do the best you can to alleviate the concerns, understanding that 99% of the time that will work and 1% of the time it won't, and you'll always have the ones who just refuse to acknowledge, and then you deal with them. Hopefully, if they act out in ways that impact the plant or the safety of others, you take action. But so far, knock on wood, we've been able to deal with those who are afraid
and give them enough comfort level to be able to function and come to work.
Thank you. Thank you. To switch gears with the panelists just a little bit is to jump over to leave and accommodations, because I want to make sure we have time to address some of those questions as well. Josh, one of the things with ARDA is, you've got 28 locations in 13 states. How are you keeping up with the different laws, executive orders, et cetera? Any tips on how to manage that?
It's a great question. I think the team and I have been thinking about that throughout this. I think it first starts, have your subject matter experts, like law firms, Seyfarth, and know where you're going to go for information. Divide it up maybe amongst the team, so that assigning specific individuals, even if it was outside of their normal area, in normal times, to be aware of these things, just because of the fluidity and just how sudden all these things were doing. Also making sure that our non-legal colleagues knew, if they become knowledgeable, because sometimes they would, the plant manager in a specific state is going to hear first about the governor order, just have them send us the info, and then we'll be on the lookout for it. And then there have been other sites and news wires in the state. The various Department of Health for the respective states usually had email sign up so you could get early warnings. And frankly, on the early days of this, back in March, April, I remember multiple times in the middle of the night doing a scan of what the updates were as the various the shelter rules came out, which I think were probably the standout in my mind as the most dramatic initial announcements.
Yeah. And Scott, anything, Treehouse's, what's Treehouse's perspective been on this?
Well, very similar, and, we've had to, with your help, Seyfarth, and very up-to-date help, much appreciated. We've had to keep track of city, county, state, federal, and they are changing on a daily basis, and new ones come in. We have 40 plants scattered throughout North America and Italy, so we've done that. We've also, and this may be more of a emergency planning kind of concept or project management, which is we've set teams up at both a high level cross-functional team, and then below that, work streams, specific task forces. And, I and others make sure that whenever something changes in any jurisdiction at any level of government where we are, all of them know of it immediately and can act. And, so far, and things have slowed down a bit. I'm wondering if it's just because a lot of government officials are on vacation these few weeks, but things have slowed down a bit so we can manage that a little better. But so far that's worked. And as long as the right people know and are talking to the right people at the management level and at the plants, so far, we've been able to at least adapt and be flexible enough to address things when they change minute by minute.
Thank you, Scott. So slightly different topic is lately we've seen this explosion of travel orders in place, and Midwest initially didn't have much, but now we're certainly being put on a number of lists. I'll start with Josh here, but how are you discouraging or communicating to your employees that visit states that will then have a 14-day quarantine upon return?
Right. So it is a great question because certainly it raised a lot of sometimes some tensions, because we're not going to tell folks that they specifically cannot go somewhere. That's not our right to do so. But we can tell them, if you do go to a state and designated, whether it was designated a hot zone prior to your departure from your home state, or then becomes a designated hot zone during your travel, that you're running the risk that you're going to have to quarantine when you return. And we were very clear on that. There creates some concerns at times and pushback from some of the various constituents in the workforce. But I think it was, at the end of the day, that clarity was rather, in some ways, easy. And then we have to monitor the quarantines. And at the end of the day, we all have to be responsible for the decisions we're making.
Thank you.
If I could add to.
Of course, please.
Yes, and like you, we've had to deal with that as well. Sort of one of the things we've done is like many employers, even who aren't subject to Families First Act, we have 80-hour coronavirus emergency leave. And, when people vacation, for example, in a restricted state, they may not know it's restricted knowingly. They may not know, it may become restricted after they were already there in those kinds of situations. So our philosophy has been, if you vacation somewhere and it's restricted, you'll have these 80 hours of leave if you haven't used them up yet. And then after that, it may be your quarantine unpaid for a while. Again, depending on the situation and the scenario, keeping up on what the person's story is. We also, many of our plants are along the border of many states. And so we have a lot of employees who, for example, live in Wisconsin and cross the border into Minnesota or into Illinois. And technically, every time they come back to work the morning of, they should have quarantined for 14 days first. Because we're an essential industry, we've been able to get around that, but that creates problems for us that we just have to think through. And the last thing we do is our entrance procedures, where people are asked the questions about, have you been exposed? Do you have temperature? Have you been sick? It's also about traveling in restricted states. And again, with the updated information we get every day, we have to change our posters every day to say what the restricted states or counties are on that particular day and make sure employees see that so that we can make sure that they are answering the questions correctly, and then we can take action if necessary.
I wanted to give our Seyfarth panelists an ability to jump in and then build on those answers. But, Ellen, I come to you. How have you seen the nature of requests for accommodations change over the pandemic? Is it something where it's been consistent, or you're seeing some variation as time progresses?
I think we've seen some progression. I think the most difficult thing right now is someone who is in the high-risk category and how an organization is going to address that, and whether or not, if it's required or not, are they going to, as an organization, have the philosophy that you're not going to make somebody who's in a high-risk category, even if they don't have documentation that the doctor is concerned they're going to get COVID and more than concerned, how are they going to treat that person? So many employers I work with are allowing that individual still to not return to the office. And I would say, the issue there is going to be, if you can telecommute, great. But if you have a job where you can't and now you're returning to the office, I think at some point we're going to see a lot more people who are getting near indefinite leave if, God forbid, this continues to go on for many more months, and how we're going to address that. So I think that indefinite leave question is going to be out there maybe sooner than later. And Corey, I would like you to ask our panelists on the quarantine after travel, whether or not they have ever considered, if somebody goes to a state, comes back, has to quarantine, does not have any accrued paid time, or it's an organization that doesn't have any COVID type leave, have they considered moving from unpaid leave to counting the time off as occurrences? I'm working with some organizations where they're frankly having trouble keeping their workforce intact, and they're looking for ways to say, don't go to those states, right? Please, we need you at work, go somewhere else, and that may be a vehicle to do that. So I'd love for you to, I guess you don't have to ask the panelists because they can hear.
I don't, Ellen, you can ask him much better than I can, so I throw it out to Scott and Josh.
I can add a little flavor to that. We have thought through that carefully, and we have not yet gone down a hard path of occurrences because it hasn't happened enough. One of the reasons, as I mentioned earlier, we look at each situation individually is we make sure employees know what the restricted states are. And many people have planned vacations. Many people maybe don't keep track of the news and know what's going on. But if we tell people, we make sure we know whether they are knowingly taking the risk themselves, and we even document it too, and then we can decide after they come back what we're going to do. But we haven't had to go down that path, but I think it's not unfair to think about it. Right now, we're trying to be more accommodating than we really have to be in so many realms, and so far we've been in that realm as well.
Yeah, I think it's a very similar experience for us is going to the more accommodation as opposed to taking any hard and fast actions, understanding the various and changes that are occurring all the time, and people not necessarily having a bad intent when they're making a vacation plan, but understanding that we also need to protect, the greater population upon their return. The other point I was going to make would be, a lot of the conversation, and this still comes up from time to time, is I don't want to be the decision maker as a governing medical authority. So we want to go by whatever the CDC and or the local medical authorities' guidance is on whether it be a quarantine or whatever. Now, of course, we're going to then implement changes and to make sure that they work in our plan and industry where applicable. But I don't think, it would be wise for any of us to become the decision maker that says, oh, well, I saw in the news that Chicago all of a sudden is a hot zone, so we're going to say no travel to Chicago.
Yeah, and one point I can add to that is some people are traveling for vacation to take care of others who need help because of the virus in their state, child care, and especially the upcoming fall semester, and many jurisdictions now you have to stay, kids can't go in. It's hard to treat that person who does it for that reason the same as the person who goes to Florida to be on South Beach with 500 other 20-year-olds.
Yeah, thank you.
I'm going to say at this point, thank you, Ellen, for the question, but I'm going to step into the shoes of the audience right now and thank the four of you for this hour-long presentation and conversation. In particular, our in-house leaders who have given their time to add to all of our knowledge, and thank you very much. I would just add for folks that are on in the Q&A, if we didn't address, I'll remind you that if we didn't address your particular Q&A, someone from Seyfarth will be reaching back out to address that specific and provide an answer to your question. But I thank you all for joining us today.
Thank you.
Thanks, everybody.
Thank you. This concludes today's webinar. We encourage you to explore Seyfarth's COVID-19 Resource Center at seyfarth.com, where you'll find more helpful information on COVID-19, including today's recording presentation. Thank you for attending.